May I beg your lordship's indulgence to mention item number 2. Your lordship will remember, my lord, that railway matter. That railway matter, I took 1 week time to, my lord, interact with my clients. Now, my lord, I don't want to praise this petition.
You want to press this petition? Yes, last occasion. Yeah.
I prayed for a week, my lord, so that I can interact with my client and convince them.
So you want one?
No, my lord,
Okay, fine.
I'm not pressing this petition.
Okay. And the concept of the petitioner has submitted on instructions that he does not want to press this petition. In view of that, this written petition is dismissed as not pressed. Thank you.
God bless.
May I please, your lordship. In item number 17, my lord, I have filed an additional affidavit.
17.
17, my lord, additional affidavit. Yes, sir. That may kindly be called for, my lord.
This will be called from the office.
My lord. Yesterday I have filed, my lord.
Next week along with we'll put it in the next week along with the because now it may be
Yes, my
we have
lord.
to also go through the affidavit. No?
My lord, please, my lord.
Nikhil, and concept of the you are for the petitioner or
I am for the appellant, my lord. It's an
appellant?
additional my lord.
When concept of the appellant is submitted that he has filed an additional affidavit yesterday only.
Yes,
Stop office to take the same and list this matter after a week.
the date may be fixed, my lord. Kindly, 2019, my
Okay,
lord.
date on so and so date that for the bit of your convenience.
May it please the
Right.
lordship.
Fine.
Lordship, may I pray for listing of an IA lordship for impleadment of party lordship. The main case is fixed on 16th, my lord. We are aggrieved by way of an ex parte interim order. Lordship, can it be listed on 16th? Oblige, your lordship.
16.
Oblige.
May I please, your lordship? With the consent of the address that I have recommended item number 18, lordship. It will kindly adjourn.
1A,
Yes, lordship.
at the request of the party, and concept of the
Respondents.
respondent. Is this matter after 2 weeks?
After on 15th of March, if possible.
15th March,
Lordship.
15th March.
Oblige.
May I plead your lordship? Lordship, I beg to mention item number 24 supplementary, my lord. Matter may be list after 2 weeks, my lord. My senior is supplementary 24, my lord.
You are for
I am for the petitioners, my lord.
appellant.
My lord.
The request of the appellant list the matter after 2 weeks.
May I please, your lordship. Lordship, with consent of the other side, I beg to mention item number 8 of the daily list, my lord.
Fine.
It is a hearing matter, my lord. On
Heavy matter.
hearing matter.
Heavy in the weight or what?
No, hearing matter. It is discussed in a hearing.
Hearing matter. I thought heavy matter.
No, some personal level on behalf of the senior counsel conducting the matter, my lord. I paid that matter will be taken up after a week, my lord.
This at the request of the council so and so, this matter, that is this rate of appeal
Yes.
after 2 weeks.
I have another prayer for withdrawal of a IM, my lord, on Friday, if possible, my lord.
Withdrawal of IA.
IM, my lord. I have filed a IA seeking leave to appeal, my lord. The applicant doesn't want to press the matter.
May I please, your lordship? I beg to mention item number 14. I am appearing on behalf of M. Bhagavati. He has some medical issues. Kindly,
Have you
matter may be.
informed the other side?
No, lordship.
No,
He has-
lordship, they
no,
have not,
lordship.
lordship.
He has, his wife is in dialysis.
Okay. At the request of the council so and so for so and so, is this matter
After 3 weeks,
3
lordship.
weeks?
Highly obliged. 1/4.
Oblige. Like, on behalf of the state respondent, we have prepared an writ appeal. The connected writ appeal was listed yesterday and lordship has fixed the matter for on day after tomorrow. No, I prefer listing of this appeal by the state.
That
On
rate appeal, new rate appeal.
Yes, ma'am. The new writ appeal on Thursday, ma'am, day after tomorrow.
May it please the lordship? Lordship, I beg to mention items 20, 21 and 22.
20, 21 and 22.
Yes, lordship, we had the instruction not to press these 3 appeals. So,
Appeals.
lordship, we may be allowed to withdraw these appeals.
You are for the petitioner?
Appellant, yes, lordship.
Appellant.
Yes, lordship.
Okay, then concept of the appellant on inspections has submitted that he wants to withdraw these appeals. She wants to withdraw these appeals. In view of the above, the appeals are dismissed as withdrawn.
Consequently, IAs will stand disposed. Caveat to stand.
All the IA stands disposed of.
Daily list, item 1.
May I plead your lordship, in this case, my lord, petitioner submitted his representation, my lord, page 12, my lord. My lord, respondent number 5, my lord, he is serious allegations, my lord. He is working as a Gavura, my lord. And taking money from this, my lord, poor people from issuing this certificate, my lord.
Because the definition is correct, it is a public document. Things correct. When I make a property, million
Yes,
My lord, respondent number 5, my lord, he is a Gambura, my lord, and he is taking money from this poor pupil issuing certificate, my lord. And so many pupils are file a representation, my lord. But non-consideration of this and non-action of this, my representation, my lord.
It's the material, you have leveled allegation that he is harboring the criminals and this were involved in certain corruption activities. What is the material before us? Simply a allegation on a paper. And
No,
how
my lord,
this
he is
PIL
taking
you
money
are
from my
aggrieved by
lord.
the- You are
Every,
aggrieved by the action of the respondent number 5, a particular individual or a government employee.
my
How
lord,
this can be treated as a public interest litigation?
my lord, he is taking money from this every pupil, my lord.
Where is what is the proof? What is the material you have placed on record?
My lord, that is the
All
representation.
allegations that he's taking money, he's doing this, how this PIL is material, even though you have some material, then also you have complaint against the individual who is a government servant. Do whatever you can do, you can file a complaint with the police, you can even, many remedies are available to it. How this PIL is maintainable against the individual?
My lord, petitioner's files is representation, my lord. That is I am an my lord.
Right,
Yes,
representation,
my
if it has not decided the representation, file a complaint with the police. That is the whole procedure is there.
yes, my lord.
If he is indulged in any cognizable offense
My
and he has committed any cognizable offense, file an FIR.
My lord, 221 persons are signed this representation, my
Maybe
lord. All villagers are.
21 persons, you may have signatures of 2,000 persons. How this writ petition in public interest is maintainable against the individual? Your grievance is against the individual.
My lord.
How can it be? And simply the allegations, no material at all is placed on record, no material, except this representation. How can we confirm that these representations are signed by the genuine persons? How can we,
My
what is
lord.
the mechanism with the court?
As per your lordship, lords or other, my lord, instruction may be given, my lord, movement, my lord.
To whom? Representations, yes, what happened to those representations?
My lord, the inquiry has been conducted against the Gambura.
Fine.
And my lord, after he found something and he was pending departmental proceeding, he was placed under suspension.
He was already placed under
Yes.
suspension, then what remains, then you can't say to be removed from his service. Actually, the proceedings in accordance with the procedure will take place, and then if he is found guilty, then suitable punishment will be.
A copy of the suspension order. It's a long back, the April 2023, he was placed under suspension.
2023.
There is no complaint.
This litigation is filed by the petitioner. The design of public interest, essentially raising a grievance against respondent number 5 who is working as Gaon Burha, BURH, Gaon Burha, government Gaon Burha. In the Rupahi Revenue Circle in the district of Nagaon, Assam. Full stop. Allegation has been labeled that the respondent number 5 has brought all the economic and official of the villages under his grip by illegal means and let loose extreme corruption and hooliganism, organizing a group of hooligans, antisocial elements, criminals and land mafias, and started the rule of anarchy in the locality. It is also alleged that the respondent number 5 formed a nexus with the local revenue, police and other officials and made himself as the solitary rule of area controlling all activities. And if anybody is protesting against his misdeeds, is entrapped in criminal cases. We have gone through the contents of the writ petition and has also perused the material available on record. Stop. Essentially, the writ petition is filed by the petitioner leveling allegations against the respondent number 5, who is a government official. But in support of the said allegation, no material is placed on record except a copy of the representation said to have been submitted by the villagers to Honorable the Chief Minister. We are of the opinion that a writ petition leveling certain allegations against the government official cannot be termed as a petition in public interest in strict sense. If the villagers has any grievance against the government official, they can avail appropriate remedy available to them under the law, such as filing complaints to the higher officials, and if a government individual is involved in criminal activities, complaint can be filed with the police also. Full stop. Then counsel appearing for the respondent state has informed that acting on the complaint filed by the villagers, the respondent number 5 has already been placed under suspension by order dated 28/4/2023. Be that as it may, we have already expressed the opinion that this petition cannot be entertained as a public interest petition. Hence, we are not inclined to interfere in this matter. The same is therefore, the writ petition is therefore dismissed.
Item 3 and 4.
I don't, this matter may be fixed for hearing, my lord.
For hearing,
Yes, my lord.
is for,
It has come under,
it is already admitted,
yes, my
matter
lord.
is already admitted.
Yes, my lord.
Yes.
If the respondent doesn't want to file any reply, my lord, that can be fixed for
That's
hearing.
what the response. We can. The writ appeals are already admitted. Therefore, be listed for hearing in due course.
For hearing, item 5.
Yeah, please, your lordship. Lordship, by the last order, lordship, I was directed to file the copies of the original OAs. Lordship, these are, lordship, not available with the ministry, lordship. I have to take out certified copy from the CAT, lordship. Lordship will give me 2 weeks time for that, lordship.
Copies of the original, you can have it from the concept of the other side.
My lord, some matter, more matter lordship have been taken with the, this was a common judgment
It
lordship.
was a common judgment.
And in respect of one OA lordship, I am appearing.
Otherwise, lordship, the issue relates to lordship, the year of allotment and the year of, which has to be considered as the year of lordship
So for
consideration.
what purpose the court got this copies of the OA?
Since lordship, it was from a common judgment,
Fine.
therefore lordship.
Okay. Mr. Alkali Chaudhary, PGSI seeks some more time to produce the additional documents on record. Time frame for is granted. When
Lordship will give me at least 2 weeks time, lordship.
just after 4 weeks,
Lordship.
take your own time.
Item number 6.
May I plead your lordship. In this case, I am appear on behalf of respondent number 1 to 4, lordship. May I pray for some accommodation, lordship, for 4 weeks, lordship.
My lord. I have no objection, my lord. Date may be fixed, my lord.
On 15 March, if possible, lordship.
List on 15th of the, at the request of the concept of the respondent, list on 15th of March, 15th of March.
Yes, lordship. Obliged, lordship.
Item 7.
Who's appearing for the central government?
Lordship, I am appearing for the central government.
Why you are not including the transgender community in the Ayushman Bharat scheme?
Lordship, it is not that they are not included. The beneficiaries who are enlisted there, whoever is enlisted, Lordship, in fact, they are eligible for the benefits under the Ayushman Bharat scheme.
The transgenders are enlisted in that.
Yes, Lordship. Now, as per the last order, Lordship, the state government had furnished an instruction. If your Lordship will have the instruction dated 25/10/2023.
25/10, yes.
And the state government had furnished an instruction. And
The chief executive officer, Atal Amrit Abhiyan Society.
yes,
Assam.
yes. On the basis of that, Lordship, I was supposed to take the feedback on point numbers 4, 5, 6, and 7.
Yes,
Now, Lordship, although I have written to the ministry, Lordship, there has been no response to that. But if your Lordship will see, these benefits are in the pipeline. This,
the pipeline
For-
is the order dated of 2023
yes,
or
Lordship,
22.
23, Lordship.
So 2020, October 2023, November, December, January, and now Feb. 4 months, still it is in pipeline.
No, Lordship, they are contemplating to give these benefits, Lordship. So when the
Contemplating, what do you mean by contemplating? They are, this is their right.
Lordship,
It's not like that, okay, you have to include some new persons in that. It is their right.
no, it's not about including new persons, Lordship. If your Lordship will see, I may just read out for a moment, Lordship.
Read.
As communicated by the National Health Authority by their letter number so and so dated, the Ministry of Social Justice are planning to extend comprehensive healthcare benefits to transgender persons under the broad name AB PMJY Smile. This scheme intends to provide healthcare benefits to 5 lakh, up to 5 lakh rupees per beneficiary per year to all transgender communities across the country.
Yes.
APPMJY scheme covers treatment based on so and so health benefit package along with additional 50 specific package related to sex reassignment surgery. And Ministry of Social Justice Empowerment has identified 149 hospitals across the country that offers SRS treatment facility, and steps are being taken to onboard such hospitals for ensuring availability of SRS packages for beneficiaries of AB PMJY Smile. Guwahati Medical College and Hospital is also included among the 149 listed hospitals. The scheme is in the progress of getting launched, and all transgender persons holding certificate by national portal so and so will be able to get the benefits of the scheme once it is launched by the NHA. So once Lordship, the scheme is launched, Lordship, they are eligible for all these, Lordship.
The scheme is already launched or not?
No.
So how much time it will take?
That Lordship, I have to take some instructions of them.
Take the instructions, the matter is pending since
18.
2018.
Yes.
It's essential time has already been.
No, this has come subsequently, Lordship.
Subsequently, but after that, this is also October 2023.
No, Lordship will see the initial petition filed by the petitioner, Lordship. The prayer was different, Lordship. Then subsequently, it has been amended and this has come newly, Lordship. Yes, Lordship.
Sir,
I understand.
this amendment is already allowed, then it's a part and parcel of the
Yes.
petition.
Yes, your lordship.
You have to extend the benefit of the certificate. You can't discriminate with them.
No, there is no question of discrimination, Lordship.
Yes.
There is no question of discrimination, Lordship.
Then
State legal services is operated party. क्या बोलना है? Petition.
The court has already taken note of this,
Yes, yes, by the last order.
of the communication.
Yes, Lordship.
And on 15/11/2023, specific, you were directed
Yes,
to seek instructions. How
Yes.
as to how the Indian Navy is going to address the said issue.
yes, Lordship.
And that is of 15/11/2023.
Yes.
Despite that, still you have not come with some concrete proposal on the day. Then you submit, otherwise they'll call from to the medical health and secretary to the Union of India central government. को बोलना
Lordship will give me one opportunity, Lordship.
Yes, ma'am.
Your lordship, to understand this entire catena of this PIL contention raised in this PIL, you have to understand what is the background of this. So even after this, India got independence, when the Constitutional Assembly debates were been going on, each and every member of that parliament, the then parliament, they discussed about the various rights, but nowhere the trans was being discussed, the rights of the trans person. Simultaneously, what happened? That India got independence and it took 65 years. And it was only the Supreme Court and the National Legal Service Authority who came up by filing a petition, PIL in the Supreme Court, and then our rights were established. So normally what the other gender binary norms who have been enjoying the various democratic rights, we are enjoying it from 2014. Otherwise, we were being termed as born criminal by the Criminal Tribe Act 1871. And after that, what happened is, your lordship, after 2014, what are the subsequent developments? The subsequent development is, in 2016, the government came up with a bill, which is one of the most derogatory in nature and one of the most nastier bill, which received the loss of protest. And why I'm calling it a nasty? Because the Supreme Court in 2014 Nalsa judgment said the transgender persons have the right to self-identify themselves as transgender, either as male, female, or third gender. Now this 2016 bill, what happened is, the executives, they diluted the direction and they came up with a bill which was tabled before the Lok Sabha, and where it was mentioned that transgender means a person who is neither born as male, neither born as woman. After that, this receives a lot of protest throughout the entire trans community from India. And recently, subsequently, this bill got passed by Lok Sabha, but got signed in Rajya Sabha. So the government could not came up with this bill. And after receiving lots of recommendation, in 2019, finally came up with an amended bill. And this got passed by the Lok Sabha, Rajya Sabha, and simultaneously received the assent of the president and becomes an act, which is the 2019 act. So now, as per section 15 of this 2019 act, this is our right. We are not asking for anything else. So now what happened is, their ideology, your lordship may keep that act, because sometimes what happened is when we are coming up with the trans PILs, so the court doesn't have this act. So that is why.
Is here.
Yes. So after that, what happened, your lordship, is, suppose a trans person has to undergo many transitional periods. Now, suppose, for an example, assuming a person is a diabetic patient, he may have some other repercussion as well. We just can't normally allow, and we can just normally allow the doctors to give any other medicines, which may have effective repercussion to that body. In that same scenario, the transgenders who are in transition, they may have a separate expert to look after them. That we doesn't have till date. So suppose tomorrow, while during the transition, if a transgender suffers anything or any medical issues, where we will go? There is nothing on record from 2018 to till 2024. And whatever this smile, which was they were discussing, the other side was discussing, this smile, the Ministry of Social Justice and Empowerment signed up a memorandum in the 2022 with the Ministry of Health and Family Welfare about this SMILE. Till date, it has not been launched yet.
No, this letter or whatever the communication by the central government or this office of the chief executive of Atal Amrit Abhiyan Society Assam. So there are certain points, around 7 points are there.
Yes, yes, Your Lordship.
So if these whatever they have proposed to implement, if it is implemented, then more or less your grievances are satisfied or what?
Even though that is not satisfied.
Let them
Why?
implement this, then anything remains, then we'll consider it.
No, because why, Your Lordship, I'm saying this?
Right.
Because when this parallelly each and every developments was going on to bring up a Trans Act, parallelly, the government of India came up with 2011 population census.
Yes.
That 2011 population census records that Assam has a trans population of 11,374, which has now gradually been developed and increased. At the same time, the government of India again introduced the socio-economic caste census. Now, in that socio-economic caste census, the transgender population was recorded merely approx 2,000 or 2,500. So, which is a conflicting with the 2011 population census data. Now, government, what happened is, now the ministry government of India said that whatever the population record we have done as per socio-economic caste census, only they were be eligible for acquiring the benefits of Pradhan Mantri Jan Arogya Yojana, which is Ayushman Bharat. Now, simultaneously, this was being discussed and this was being argued from both the sides. Now, this 25/10/2023, this letter, if your lordship may see, point number 1.
Yes.
Ayushman Bharat Pradhan Mantri Jan Arogya Yojana is a central government health assurance scheme which provides cashless medical benefits up to 5 lakh per family per year in AB PMJY Empanel Hospital to Aadhaar linked NFSA. Now means a trans person who will be having an Aadhaar and the ration card, only they will be giving the benefit. Is it not a contradictory to section 15 of the Trans Act 2019?
Linked to national food security beneficiary.
This is meaninglessly been keeping on dragging this matter from 2018 to 2024.
But if the ration card and Aadhaar card is necessary for any other person or for any category of person, then why the transgenders are not required to have an Aadhaar card or ration card?
Now, your lordship, the issue is many of the trans persons being a trans, sometimes they are being thrown out by their own parents. Some of them leave their own house just because of the continuous social humiliation from their own family and from the society. Some of them doesn't even have any documents. So this we tried to brought before the Supreme Court in the NRC petition. Why this NRC petition we challenged in our IA was, your lordship, because many of the transgender person who are being disowned by their own family members, normally they don't even have any kind of documents. So now, without being documents, will they be treated as a foreigner?
It seems from this communication of 25th of October that the central government is contemplating to introduce a separate scheme for the transgender persons. The point number 4. As communicated by the National Health Authority by letter dated so and so.
That is what
are planning to extend comprehensive healthcare benefit to transgender persons under the broad name of SMILE.
Smile. That is what I am submitting, your lordship.
The scheme intends to provide healthcare benefit up to 5 lakhs per beneficiary to all the transgender persons living across the country. So in that case, I don't think so there is a requirement of Aadhaar or ration card.
But
And
point
that
number
is a
1.
separate category and a separate scheme for the transgenders.
Now, point number, again, this is a derogatory. Why I'm saying this, your lordship? Because if your lordship may just see chapter 3 of the Trans Act 2019.
Yes.
If your lordship permits me to read so that I will clarify. So chapter 3 says recognition of identity of the transgender person. The procedure here has been laid down how a trans person will be able to acquire ID card and certificate, and why that ID card and certificate will be necessary to acquire the various schemes and benefits, whether under the state government or whether under the central government. Now, this becomes contradictory when they say that PMJ empanel hospital to Aadhaar linked NFSA.
Where is that?
Point number 1 of their letter.
That is in respect of all the category. But here, point number 4, what we gathered here, that they are going to launch a separate scheme for the transgenders where they may not require any Aadhaar card or ration card.
That is what I'm submitting, your lordship. Because for this SMILE project, if your lordship may call for the records from the ministry, your lordship will find that already there was a memorandum which was signed by both the Ministry of Social Justice and Empowerment, and by the Health Ministry back in the year 2022. But even though from 2022 till 2024, nothing has been done.
What are the terms of those MOU?
We don't know, because it was never been disclosed to us. Only just we were being invited to New Delhi where they organizes a meeting. All the trans persons, we went there, and we just came to know that government is coming up with a SMILE scheme, which will give a comprehensive health policy to all the transgender marginalized sections. But what is the ingredients of that MOU? We don't know till date.
What is the scheme? Still, they have not launched any scheme.
Nothing.
Mr. Rai Chaudhary,
Lordship.
please get the confirmation when they are going to implement the scheme, or what is the contents of that scheme,
I will get that, Lordship.
that their grievances are addressed or not. Whatever it may be, you please, when the court has already granted you, but
I got the Lordship.
Because the main problem is, your lordship, suppose if any transgender meets with an accident, or suppose if any,
it seems the government is contemplating to give some benefits or whatever the benefits to you under that scheme. So let's
Once
form
the
court
scheme is
that
launched,
the
maybe
scheme
they
and,
would.
what they are proposing, and then we'll see what they are giving and what they are lacking. Then only we can see. Otherwise,
because your lordship, again, section 15, if your lordship for the time being, if your lordship may just say section 15 of this act, section 15 clearly specifies
read.
that the appropriate government shall take the following measures in relation to transgender persons, namely, clause A, to set up separate human immunodeficiency virus serosurveillance centers to conduct serosurveillance for such person in accordance with the guidelines issued by National AIDS Control Organization in this behalf. Clause B, to provide for medical care facility including sex reassignment surgery and hormonal therapy. Clause C, before and after sex reassignment surgery and hormonal therapy counseling. Clause D, bring out a health manual related to sex reassignment surgery in accordance with the World Professional Association for Transgender Health Guidelines. Clause E, review of medical curriculum and research for doctors to address their specific health issues. Clause F, to facilitate access to transgender person in hospitals and other healthcare institutions and centers. And clause G, which is very important, provision for coverage of medical expenses by a comprehensive insurance scheme for sex reassignment surgery, hormonal therapy, laser therapy, or any other health issues for transgender persons, which is already there in the statute. Why they are taking so much of time by causing trouble to the community persons?
That's a matter of concern. But it seems that section 15, whatever the points are there in the section 15, broadly, they are covered under this point number 4, 5, 6, and 7 of the letter dated this 25th of October.
Yes, your lord.
Let them respond what the government is doing since it's almost 6 months.
Lordship.
You inform us by the next set of hearing what we are.
I will do that, Lordship.
Okay. On 15/11/2023, the coordinate bench of this court granted time to Mr. R.K. Dev Chaudhary, learned Deputy Solicitor General of India, to complete his instructions as to how the Union of India is going to address the issues which has been quoted in the order dated 15/11/2023. So Mr. Chaudhary raised some more time to complete his instructions. Stop taking into consideration the fact that as per the communication dated 25/10/2023 from the Office of the Chief Executive Officer, Atal Amrit Abhiyan Society, Assam, certain benefits are proposed to be extended to the transgender persons over even after lapse of around 3.5 months. No specific information is provided by the provided. We deem it appropriate in the hour in provided. In the interest of justice, 4 weeks time is further granted to Mr. Chaudhary to complete his instructions. List after 4 weeks. See to it. And make it sure.
Obliged.
Item 9 to 11.
May it please your lordship. In this case, lordship, there is a appeal preferred by the state and also preferred by one of the private respondent. The core issue which was involved before the learned single judge was whether regarding the maintenance, whether an issue relating to the IS cadres nomination, lordship, they should go to the CAT, Central Administrative Tribunal, or they can come under Article 226 to the Honorable High Court. So that was the issue. And that preliminary issue, when it was heard, the learned single judge was pleased to delve into the merit of the case also. Our affidavit on behalf of the state was filed.
So ultimately, what was held? It is maintainable before the CAT or the?
The learned single judge held it was maintainable before the CAT, and while passing that order, when it was heard and the affidavit was also filed, the Honorable Court was pleased to give some opinions regarding on the merit also. And
Despite
also
holding-
allowed us to file affidavit.
Despite holding that the matter is to be heard by the CAT.
No. It is maintainable before, this particular issue is maintainable before this Honorable Court under Article 226.
Then even if some observations are there, how do you?
Observations are there. Now the issue is not that. The issue is that two incumbents against whom the association came, both of them have superannuated in the meantime. Whether they would still like to continue with their process or not. If they want, because it will be basically on academic interest, the case will continue. If they have a different opinion, then lordship will maybe pleased to hear the matter.
My lord, there can always be review DPC. So the person who were, promoted, actually, my lord, we are the civil service officers of the state. The two respondents, my lord, who were nominated to IAS, they were non-state civil service.
Right.
Our basic case is, my lord, an equivalent exercise is to be undertaken by the state before nominating the name of non-civil service officers.
Which exercise?
An exercise to equate, my lord.
Okay.
That means an officer whose name would be recommended, he should be of the equivalent to that of an deputy collector.
Okay.
Now, one of these tax officer, he was superintendent of tax. And his name has been nominated. Number one. And number two, my lord, the quota was only one in terms of the relevant regulations and the rules. 2 persons were nominated. That way, my lord, our quota was eaten up. quota of the state civil service officers, which is 33.13. And non-state civil service officers quota is, my lord, 15% of 33.13. That is, in this case, 5, it was only 1, whereas 2 officers were nominated. Now,
Administrative Tribunals Act.
Against now, once their appointment is declared to be bad, then naturally, my lord, one was nominated subsequent year. His year of, allotment will be treated to be of their earlier year. Therefore, the cause of action survives.
Mr. Sekia,
Lordship.
so you are challenging the finding of the learned single judge regarding the maintenance.
Exactly, Lordship. All
They
these
also-
things are on merit. Whether they were rightly given the nomination or not, all this can be, whether the,
First of all, though, we have addressed the issue whether it is maintainable.
Exactly,
I don't
Lordship.
know the case.
yes, Lordship.
And you are challenging that also.
We are challenging because our whole challenge was regarding the maintainability. Whether they should go to the CAT or they can come before this court. That was the issue. If they want to pursue, then Lordship may be pleased to fix a very short date for hearing, Lordship, because today I thought that they will not pursue the matter. If they want to pursue, because both the persons are no more in service.
My lord,
You should
my
have asked them
learned
in
friend,
the advance.
my learned friend took lot of time to produce the record. That's why, my lord, these people are superannuated.
No, if,
Or can you see the order sheets, my lord? On how many occasions they have taken time?
no, we have
Every
taken,
time
we have
the
filed a
matter was
detailed
heard,
affidavit.
they will produce some record, the matter got deferred.
No, Lordship, that thing
Yes,
is,
yes.
if I have to say all these things, then I have to take your Lordship to all the affidavit, which will be.
This writ petition was filed by the association.
Association. The beneficiaries are no more there. That's why whether it can be an academic exercise now. That is why I was thinking, Lordship.
And
If Lordship wants to hear, we are not.
in some sense, we can say it's only academic exercise. Since
Yes.
the persons who have already been granted benefit, they have already been superannuated, therefore now we can't recall that whatever.
No, my lord, there is a learned single judge judgment declares their selection as bad. So that will remain then if they withdraw their appeal. So they
No,
have
no,
to
we are
pursue
not
the
going to
appeal.
withdraw it. We are not going to withdraw it,
No,
Lordship.
very possible,
Otherwise, my
very
first
possible.
submission would be, I am going to withdraw. No, that is not my submission. There's a stay of the judgment and it has to go to the learned single judge because the learned single judge, while holding it maintainable, passed certain observations without there being an opportunity for us to file affidavit. Our affidavit was to a single point. It is not maintainable. On merit, the state as well as the other private respondents did not say anything. Only on the sole ground regarding the maintainability. The law is well settled. A 5-judge constitution bench held it. That all these issues should go to the CAT.
So you filed this writ appeal against the
In interim order, Lordship.
26th of August. Then Satyajit, we are not supposed to make any comment on merit and only to address whether this writ is maintainable or not.
Absolutely, Lordship.
Is what the we feel.
Counter was filed on here. Counter was filed. They have filed.
So yes, today you are ready.
Lordship, today I am not ready. Let it be on 21st or maybe on Monday 19th.
I have to warn the private respondent. I have to have come against the order of the learned single judge. By the time my client is also retired long back.
But now, this,
That's also, we have also raised the same point, mentability is not mental before the learning single judge.
in fact,
Again,
what we are
we-
contemplating that we are, only have to address the issue regarding the maintenance.
accept
So far as the merits of the case, that is for the learned single judge.
Lordship.
to take.
Decide, yes.
Right.
Day after tomorrow also, no, on Friday also, Lordship, maybe please take it.
No, no, Friday morning.
This Friday.
No, Friday
the-
I have some difficulty, but let it be on Monday. Monday, Tuesday, any date convenient to Lordship.
Tuesday, 20th, 20,
21st.
Lordship. Highly
Mr.
honorable.
Mr. Saikia,
Lordship.
which is the section you are relying on for, to say that there is an ouster of?
1-4.
One thing.
Law is well settled, Lordship. This is no more res integra. The Honorable Supreme Court always said that the cat is the first court of court of first instance. For all these disputed things, whatever they are saying.
But despite that, even though if the cat is the jurisdiction, how can you restrict the jurisdiction of the?
High Court.
and
That is a
the-
5-judge constitution bench has restricted it. Otherwise, everybody would come here.
Let's see, relied, L.
The-
Chandra Kumar. will
L.
rely.
Chandra Kumar's
L.
case.
Chandra Kumar will rely. Can we
And
rely
law is still
successfully on-
continuing.
My lord, in L.
We
Chandra-
always prefer to come before the High Court as a state also,
My lord,
instead of going there. But the law is like that.
The cat says in L. Chandra Kumar, my lord, the Honorable Supreme Court has used an expression, areas of law. So whether it is section 14 or 15, that's the issue.
Highly obliged.
Thank you.
Item 12.
Yes.
Lordship, I appear for the respondents, Lordship. The appellant has challenged an order which your Lordship will find at page 78.
Appellant is not present.
Who is for the other side? Assistant SGI, you are for the, this,
Appellant is not present.
S, Bora and Chakravarti. Miss Bora. Present exam.
Item 13.
Well, this matter relates to the provincialization of service of teacher, assistant teacher.
The private
Provincialization. Into payment for large letters is ordered situation is due in the benefit. Then payment is also order is payment one large letter provincialization order to know. This into benefit detail again. Now it one large letter order is this keeping it in the conclusion of the order to receive payment. Order to her. Itu benefit palu, into payment to do financial benefit. It's all in. Give them the benefit of provincialization. He became. Yeah.
কিন্তু কোৱা নাই এতিয়ালৈ।
Transfer to इतना मैं नहीं आता। On request to. Government. But you. Or. ये 94 में भी आएगा इस तरह
Yes.
My lord, in the year, the fact is that in the year 2013, as per the Provincialization Act 2011, the name of the one of the junior assistant teacher junior to me was recommended. Therefore, I filed objection. And one clarification is also there. My lord, kindly peruse Annexure 1, page 31, where the headmaster, page 31. Where the headmaster specifically stated that it is a oversight mistake and I am the senior. Page 31, Annexure 1. My lord, at the bottom, Kalpana Barua is the appellant here. Joining date 21st of October 84. And the other person, Gopal Buragohai, 10th of April 94, almost 10 years junior. Thereafter, my lord, although this was given, but my name was not recommended. Therefore, I filed one writ petition. And on the first date, the provincialization of that private respondent was stayed. And that order is at page 38, Annexure 5. And relevant portion is at page 39, last paragraph. In the interim, provincialization of service of Gopal Buragohai, that is the other party, this and that school should not be granted. And thereafter, my lord, the honorable single bench disposed of the matter, directing the director to take pass a specific speaking order, that is at Annexure 6, my lord. The direction is at bottom. Page
41.
my lord, 40. 41 is the 42 is the relevant portion. Last paragraph. In the view of above, the writ petition is disposed of directing the Director of Secondary Education to take on accord the grievance of the petitioner and pass appropriate order expeditiously. Thereafter, my lord, speaking order was passed at page 44, Annexure 7, where my claim was rejected. Showing that I was not attentive or was not a good teacher, that is the reason. Annexure 7, page 44 is the speaking order. 45 is the relevant portion where my name was not finalized. Against which I again.
Therefore, I do not say this is not recommend the name of the Kalpana, what was the assistant teacher, what was it? Today, in the time of when I advocate appealing for the petition, Gopal was tried to force to give voluntary relinquishment from the FIR was law. As such, it is necessary to hear the present managing committee and the administrators of the topic from. They, administrators statement recorded, knew that Karna was joined it like that. Administrator, the president of Karna is inefficient. He is ill, inattentive to students.
That is correct, my lord.
Mistake in education.
That is the reason shown by them.
For this, our name was recommended. In case of, no, therefore I don't see any infirmity. But these can be proven for. Okay, then you challenge this.
Yes. Again, I have filed a another writ petition. That is, and on the first date itself, another stay order was granted. That is at annexure 9, page 51. And 11 portion is at page 52.
9 page 51.
51 and 11 portion is at page 52. Order passed by this honorable court, interim order. Last paragraph, 52 page.
Having regard to submission made and considering the material, beyond speaking order passed by the director is hereby stayed until further orders. Okay, fine.
My lord. Thereafter, my lord, in the meantime of pendency, annexure 10, the director was so hasty in nature that he provincialized the private persons. Also having the knowledge of this interim order at page 10, page 53, annexure
In
10.
violation of this order.
That is correct. Therefore, I filed one contempt petition. Annexure 11, page 54 is the order, my lord, where this court single bench has passed an harsh order direction. At page 55.
Responded deliberately flouting the order of this court, playing a cat and mouse, same court, so and so. Then
Thereafter, that order, earlier order was cancelled
withdrawn.
as per the annexure 12, page 56.
Okay, fine.
Earlier order was set
Withdrawn.
aside, and thereafter, annexure 13, page 58. This honorable single bench again directed the director to take a fresh, pass a fresh speaking order. That is 11 portion is at page 59.
Okay, done. Then
Well, thereafter, this time, after going through all the materials, annexures 14, the director passed an order recommending my name. And the date is at 9th of March 2015, annexure 14, page 60. Last paragraph, having considered all aspects, taking this and that, I see no merit in the case of Gopal Bura
and,
Gohar.
this order was passed in your favor.
Yes. Thereafter, that private person filed one writ petition. That is at annexure 15, page 62. And this is the impugned order, my lord. Where the honorable single bench rightly passed the order in favor of me, but only my grievance is that in this writ appeal that I should have given the benefit with effective from 2013, because I am fighting all this along and there are stay order in favor of me. And relevant portion is at, my lord, direction is at page 70.
Depending on the judgment of this court, judgment dated so and so, and then Kumar. When they shelter violence and all, therefore the state government, the government brought into court the application to so that is one. Other person to the full-time decision of the state government establish allegation tribunal to which the state to preside over the concerned district assistant judge was required to decide the issue regarding the seniority of the decision of since 2011 amended the basis of it, the petitioner is seeking provision in the third full number. Security the student question and attachment. What's wrong in that order? They have granted you liberty to approach the tribunal. Appropriate forum for resolution regarding seniority in the school. Means the learned single they observed that since now there is amendment and this tribunal will hear establish the educational age district legislature to be presided by the concerned district judge, the additional review who is required to decide the issue regarding the seniority of the teacher of non-provincialized schools.
My lord, I am sorry. It was dismissed. Yes. The
Infectious, treated
Yes,
as infectious.
yes. Thereafter, my lord, kindly come to page 66.
Yes.
This is the order whereby I have been given the benefit of provincialization.
Again, you have filed a petition.
Yes.
Okay.
Order. But your client has already been provincialized, correct?
Yes.
In terms of the order dated 31/5/2018. Is that correct?
My lord.
Now,
In
your,
the year
listen,
2020
1 minute.
Yes,
Your grievance is that this provincialization ought to have been given retrospective effect,
that is correct.
correct?
Yes,
That is why you're challenging this order.
that is correct. I am not challenging actually. I am just
If you're
claiming
not
the more
challenging, then
benefit.
what is there? That's it. Different
My,
cause of action.
my lord, on the only difference is there that 11 Provincialization Act was subsequently set aside by this honorable court, and new act was brought in the year 2017. And as per this direction, I was given the benefit of new act. So that is, to that extent, that is correct. But as because I am fighting since the beginning, filing 3 or 4,
But was that a prayer in the writ petition that it should be given retrospective effect?
my lord, at that time of 2013,
Please understand the thing. You may have a grievance, but how can you pursue it in this writ appeal? Because the writ appeal order has been implemented, your service has been regularized, provincialized. Now, if you think that it should be given effect from an anterior date, then you have to initiate fresh proceeding. How can the relief be granted in this writ appeal when the order itself has been implemented in your favor?
that is correct, my lord.
Then
But my only grievance is that if I go
But he said that since I was pursuing my claim, give me the benefit of the act which is already been done.
So, my lord, I would have to forum for review with the prayer for effective date.
No, you want the benefit under a statute which has been struck down by the court.
That is, my lord, only because that I am in a continuous process, first of all. Second of all,
Section 4 of the 2017 Act. The learned single judge has quoted that. Subject to the fulfillment of other provisions of this act, the services of the teachers and the tutors of all venture educational institution eligible under section 3 shall be deemed to have been provincialized by on the date of publication of provision by the notification of the official gazette, they shall become employee of the state government with effect from such date. तो जिस दिन आपका नोटिफिकेशन हुआ उसी दिन से होगा.
that is correct.
How can you claim,
My prayer is based on 2 points. First of all, I am in a continuous process and there are 2 stay order. Second of all, I am also in a continuous service. I am not that I have left my service. But the fact remains that if that private person would get the benefit, he would get the benefit from the beginning. Because his service was provincialized, order was, recommendation was given under the earlier act. So his position and my position are the same. So the state government cannot get a relief by saying that we have cancelled the earlier statute and given effect a new statute. So you would be guided by this new statute. So these are my 2 points. First of all, I am in a continuous court process and I am also in a continuous service also. So therefore, I have been claiming that benefit because this person would have get the benefit, other person, Gopal Buragohai, if he would have provincialized because his name was recommended. But as because for some fault of that had mistakes, my name was not recommended. And after a long journey, My lord, my third.
You are granted benefit from the year 2015,
17.
17.
Yes.
Since Assam, this Provincial Service of Reorganization Act has came into force on it, and the service of the shall be provided under the provisions of 2017 Act.
That is correct.
This is what the 2012 Act can't be provincialized because that act has already been declared
Madam.
as ultra virus.
That third point is relating to that point, that ultra virus. So this honorable court has passed one judgment saying that that earlier act is ultra virus because it did not give the benefit to all the
In
teachers.
fact, the assistant, that the director or the director of the secondary education has passed an order on 9/3/2015 for the first time, directing you to give the benefits. Okay, directing to give the benefits. Thereafter, the benefits have not been granted, then you approach this court, ke sab nahi mila. But now the court has taken into consideration the fact that in 2012, the act that has already been declared as ultra virus, and now this 2017 act came into force. So provincialize the services of the petitioner under that act. And that has been done. That is the possible.
My lord, to that extent, I am, my lord, accepting that point, but only my 3 point out of.
You have not heard. In fact, for the first time, your order for appointment was issued of the year 2015.
Well,
You have not worked from 2013.
Because of the pursuance of the 3 writ petition.
Whatever it may be.
And stay orders were also there.
Whatever it may be. Stay order was not there to give the appointment to you. Stay order was regarding restraining the appointment of the other person.
That is
not
correct,
of
my lord.
yours.
But as because at the last moment, it is whole that his service was wrong, my service was, I was.
You don't find it. News के अंदर आओ क्या?
These are the third points I am having, my lord.
I have supplied a copy of a judgment, my lord, of a coordinate bench. It is held that the 2000 benefits under 2011 Act cannot be given at this stage, and it is only 2017 which can be
ये
given.
पहले बोलते ना
My lord.
इतनी देर से इनको बोल रहे you should have asked this first.
So, answer, my lord. But para 9 of the judgment, your lordship. Para 9. The case as projected by the learned counsel for appellant to the effect that the appellant was vested with rights under the Act of 2011 on the date when judgment was rendered in Chandan Kumar Nayog Supra cannot be accepted. The very fact that the services of the petitioner had not been provincialized and therefore the writ petition was filed makes it clear that the case of the petitioner would not be covered within the 4 corners of the decision rendered in the review petition. Admittedly, the petitioner was not getting any salary as provincialized employee. Therefore, it would be a fallacy in law and facts to consider that right had already been vested on the writ petitioner under Act of 2011, which admittedly had been struck down by the struck down as constitutionally invalid. The review court has held that the doctrine of prospective overruling would not apply as the said power is vested only with the Supreme Court of India. It is in such circumstances it has been provided in para 19 supra of the judgment rendered in by the review court that the rights of the employees who have been benefited under the struck down statute can be taken care of by giving retrospective effect to the proposed legislation if the legislature so decides. Till then, it is ordered that the service of the provincialized category in this status as government employees shall not be disturbed and they should continue to receive all the benefits which they were getting under the Provincialization Act of 2011 since struck down by the judgment under review. We are conscious of the fact that subsequently the Assam Education Provincialization of Services and Teachers Reorganization of Educational Institutes Act 2017 first part the Act of 17 was brought into place with effect from 11th of April 2017. In the impugned order passed by the learned single judge, it has been said that no writ of mandamus can be issued in view of the fact that the Act of 2011 is not in force. However, liberty was given to the petitioner to approach appropriate educational tribunal for consideration of a case for provincialization as per law in force. In this case, the provincialization has been given.
Which is 2015 of it.
18.
The movie
You approached
15
the
of-
14, 18.
I would have guessed, yeah.
His repetition in the year 2018, the prayer was that he should be given the benefits from 30.
2013.
Right. That was his prayer, that was his prayer.
It's because I was in a continuous process of three repeats. Yes,
What about this division bench judgment? Is it there?
Today I got it, my lord.
This writ appeal is filed by the petitioner being agreed with the order dated 31st of May 2018, passed by the learned single judge whereby by disposing of the writ petition filed by the petitioner, a direction was issued to the commissioner and the secondary education department, director of secondary education Assam, and the state government in the finance department to consider and decide the case of the petitioner of
23, 80, 70.
her provincialization under the provisions of the Act of 2000, under the provisions of this 2017 Act, name of the 2017 Act is? Assam Education Recognition of Provincialization of Services of the Teachers and Reorganization of Educational Institutes, bracket close at 2017. Stop. Learned, consider the petitioner has submitted that, appellant has submitted that the learned single judge has added not issuing the direction to the respondents to grant benefit of salary, seniority, etc. from the year 2013, the date, the year from when the appellant was agitating for his rights regarding her appointment as teacher under the Provincialization Act of 2011. Stop. Then it counsel for the respondent has submitted that the benefits of provincialization cannot be granted to the appellant under the
Well, earlier it is Assam Venture Educational Institution Provincialization Service Act.
That's what I'm looking for. Assam Venture Educational Institutions, bracket में Provincialization of Services Act 2011,
Well,
as the same was declared as ultra virus by this court by judgment dated, कौन सा judgment? The date of the judgment of that.
Division bench, my lord, 13/11/2019.
The Act 2011 was declared as ultra virus. That is the judgment stay.
That is in 2016. It's reported in
And
2016.
white judgment dated
my lord,
23/9/2016 passed in writ petition.
23rd of
WP C number 3190/2012. Chandan Kumar Niyog versus State of Assam.
Yeah.
Full stop. And it counsel for the respondent has submitted that a division bench of this court in Srimati Puranbati Brahma versus state and others has already took a view that no employee can seek right under the Act of 2011, which has been struck down and constitutionally invalid. And an employee can only claim benefits. And the benefits can only be granted to the concerned employee under the Act of 2017. Full stop. Having full stop. Heard the net counsel for the parties. A division bench, coordinate bench, a division bench of this court in Srimati Purnabati Brahma Supra, considering a similar claim has held as under paragraph number 9. In view of the view of the we find no reason to take a different view as expressed by the division bench in Purnabati Supra. Hence, we don't find any merit in this appeal. The same is there for dismiss.
Well, may I pray for just one thing? As per the order dated 3rd of August 2023, in this writ appeal, I was directed to given the benefit, financial benefit that is not even yet given.
Which benefits?
Well, order dated 3rd of August 2023 in this.
He
writ appeal.
alleges that from 2017.
17 benefit is not
2022
given.
Till date, he has not been given the
Anything.
financial benefits after the provincialization. That be the case, my lord, he has the, he has given a copy to the department. He has shown me, my lord. If it is a matter of content, that can be taken up. Otherwise,
Well, a specific
I'll
order
take
is there actually. So if one,
A separate cause of action, you may approach this court with the other thing, we'll consider it whenever it will come. That is a separate cause. of action. Yes.
Obligation.
Separate and subsequent cause. Separate and subsequent cause of action.
but order is there actually. Direction is also there in this writ appeal.
File a contempt petition.
My lord, my lord, my lord.
obligation.
Item 15 and 16.
List before the bench in one of us, Dr. Nambikdin is not a member.
My lord, I may not be denied this privilege to conduct the case before this tournament.
Sir, once we are not even hearing the matter, we can't fix any date.
Item 19.
Mayor, please, Lordship, matter may kindly be passed over for time being, Lordship.
For the time being or for today?
For time being, Lordship.
Today, we'll hear it on the next week.
Okay.
Next week.
Obliged.
Your Lordship, may I pray for a date in that case, Your Lordship?
Date,
Yes.
date at the,
In that case, may I pray for a date? For a,
which date?
can it be on 27th?
27th of this February?
Yes.
Okay, you 27th.
Deeply okay.
Item 23.
May I please, your Lordship? Lordship, I am praying for a short accommodation, Lordship, to obtain instruction.
As you wish, but what will do now? Suggest us. क्या करें हम अब?
Lordship,
Suggest us हम क्या करें अब? This तो हमारा board का पूरा हो गया.
Lordship, because I have received the extra copy today only.
Simply saying suggest us, what we will do in the chambers. Okay.